Tonight, a Memphis judge ruled the daughter of an inmate executed 13 years ago for murder does not have the right to have DNA tested. Sedley Alley was convicted of the 1985 murder of Suzanne Collins. His daughter wants the crime scene evidence tested, and that's in hopes that it will exonerate her father. Well, Local 24 News reporter Jenny DePrizio was in the courtroom today when a judge dismissed her case. And Jenny, what exactly did the judge say?
Well, the judge basically said that Tennessee law does not permit the estate of a dead inmate to ask for DNA testing. She ruled that the court doesn't have jurisdiction in this matter, and it's not the ruling that Allie's lawyers had hoped for.
The truth should not be buried with Sedley Alley. If indeed the DNA will provide that truth, then we should allow testing.
Lawyer William Massey says Sedley Alley's daughter April wants the evidence tested, and there's no reason why it shouldn't be. Alley originally confessed to killing Suzanne Collins in 1985, but later recanted his confession. Alley was executed in 2006. In court, Judge Paula Scan said Alley's arguments were best addressed to the Tennessee General Assembly and the Tennessee Supreme Court. Alley's lawyers say that's because the issue of an estate asking for DNA testing after a person has been executed has never been litigated before in the state of Tennessee.
April Alley, standing in the shoes of her father in his estate, this ruling is saying that the estate does not have standing to challenge, to even seek testing at all.
The state wants to rely upon the process that ultimately ended in the execution of Sedley Alley. We want to challenge that process, and we found grounds upon which to do so.
Now, April Alley was not in court today, but in a statement she said she was heartbroken. Her lawyers plan to appeal the judge's ruling. Jenny DePrizio, Local 24 News.